Good evening and welcome to the RJOS Professional Development Webinar. RJOS would like to extend a special thank you to FAAOS for allowing us to utilize their webinar platform to produce this series.
Thank you for coming to join us, and I'm happy that we can still have this webinar. No free meal, of course, and much more dynamic in person. But we have a really great panel of speakers, so I think we should go ahead and get started. First up, we have Melissa Young, who's our AAOS General Counsel, followed by Marlene DeMaio, who's our RJOS President, and then I will speak, and then we'll be rounded out by Gaffey, who is a specialist in risk management. She's president of a company, Healthcare Risk and Safety Strategies. So thank you, everybody, for joining us.
Thank you for inviting me, Dr. Murali Larson. I'm always going to say your name wrong. I apologize about that. I wanted to introduce myself first. I'm Melissa Young. I'm the Academy's General Counsel, and I have been with AAOS a little more than 11 years. I can say, after having canceled our annual meeting this week because of the COVID-19, one of the things that's sticking out for me is a renewed respect for doctors, because I had no idea just how rough my hands would get after washing them so often. But that something tells me the doctors have known this for a while, so I have renewed respect for you. We will talk today about medical liability. First, I want to talk about the do's and don'ts of litigation. I'll give you some litigation reminders and maybe some support resources that'll help you in the event you are party to litigation. As sort of I'll call it an afterthought. I'll talk to you a little bit about the AAOS Professional Compliance Program that may be a resource for you, but only once you've gotten through that whole litigation process and put it behind you. And then I will also talk about the Academy Sports Medicine Licensure Clarity Act, which went into effect at the end of 2018. And then I'll give you a few thoughts about humanitarian and mission trips. If you've been served with litigation or you're notified that you've become a party to litigation, what do? Well, paraphrase Dr. Michelin here, chill out and then get ready. It's very important for you to prepare yourself. Litigation often feels like it is a very, very personal experience, like a personal attack, and it is important to focus on taking care of yourself through the process. You can certainly seek out legal resources that may be available to you. That's through your employer, your practice, and through your insurance company. And when you're preparing, it is appropriate for you to go over your notes and your chart from the time that you were treating the patient. In fact, it's encouraged because unless your counsel tells you otherwise, don't go beyond your records. You want to limit yourself to what you did or how you treated the patient. But even as the defendant, know that you're an expert. The opposing counsel is going to scour every word of every record in an attempt to prove his case or her case. But you need to be your own advocate, know your case better than the opposing counsel does, and work closely with your own attorney so that you can translate the facts of your case to a jury of most likely non-physicians. And that's going to be really important, getting them to understand your case. So here are some do's and don'ts in litigation. You can certainly talk to your friends and your family, colleagues about how you're feeling, but you should avoid talking about the specifics of your case. You can talk to your claims adjuster. You can talk to your attorney. If you're unsure about how to proceed, first thing you should do is call your attorney. In fact, he or she should be on your speed dial. If an attorney or somebody else that works for an attorney reaches out to you about your case directly, again, contact your attorney. Communications about your lawsuit should always go through your attorney. Let's see, we're going to move ahead. So here are some reminders. To understand the dynamics of a lawsuit, it's always helpful to remember a few things about medical negligence cases. First, the plaintiff's attorney's goal is going to be to find fault and to establish what harm was caused by something the physician did or did not do. The counsel's not concerned at all about whether it was an error or if it was an adverse result. Couldn't care less. They just want to, figure out, find somebody to put the blame on. Next will be, let's talk about your insurance coverage. The complaint itself is going to be written in a way that is very strange. One paragraph to the next, it's probably not going to make any sense. It's going to seem like it's contradictory. And you need to know that it's done that way intentionally because they don't want to have anybody excluded from responsibility at the outset of the case. They want as many people or companies, entities involved in the litigation. They like deep pockets, and they are certainly going to keep hospitals and practices and doctors involved in the case as long as possible. They want to try to maximize all the potential sources of recovery. So, for example, one complaint might allege that a surgeon made an error, but then the nursing staff also made an error, and the hospital had staff issues, and all of those errors combined caused the patient's injuries. You're certainly going to see the case a different way, but just know that the attorney has a specific goal in mind, and it really doesn't have anything so much to do with you, just using the facts in the way that's most advantageous to the client. So again, if you have questions about the complaint, call your attorney. Words of wisdom. Let's talk about that a little bit. Be contentious. Well, let me say that again. Be cautious about who you talk to about your case. If you need to talk to somebody about the facts of your case, your first choice ought to be your attorney every single time. If you are unsure about answering questions, talk to your attorney. To the extent that it's possible, don't be emotionally engaged. Try to be objective. I know that's hard, but do try to do that. Otherwise, it's a long road and it will be tough to get through it. Having said that, I also know that there is an emotional impact to being involved in litigation. It's going to feel deeply personal and can undoubtedly have an emotional impact. Dr. Delzato in Folsom, California, did a really interesting video for his malpractice carrier in which he says what's here. There's an overwhelming feeling of literally being a duck in a pond with half a dozen 12-gauge shotguns pointed right at you. So this is acknowledged by most of the larger insurance companies like the Doctors Company, PRI, and NorCal, and they will frequently offer peer support and other wellness resources. But before diving into those resources, I need to just note here that AAOS doesn't endorse any of these resources or any companies in particular, but I'm happy to provide you with some information on what might be out there and available to you. The Doctors Company has a case studies series which highlights a member's personal experience when they're facing a malpractice claim. PRI has a peer support hotline and a litigation stress resource center. And NorCal Group has a free on-demand webcast and other resources on physician burnout. But you can find Dr. Delzato's video and others by the same company, and it's posted on the Doctors Company website, and it's also on YouTube. Another liability carrier, MedPro, has a video that dramatizes a liability trial So if you really want to know what to expect, it's a 22-minute video, and it'll walk you through every phase of the trial. But definitely find out what resources your malpractice or professional liability carrier offers. In addition to these resources, you might also look at some of the offerings through other associations like American Association for Physician Leadership, and that's one of the websites there at the bottom, physicianleaders.org. There's a website that I found really interesting, Physician Litigation Stress. Just a wealth of information there. And MD Mentor, both of them are resource libraries that focus specifically on litigation stress support for physicians. Physician stress during litigation is, physician litigation stress is more of a true resource center, kind of like a library, and can direct you to other resources. They've also got a mailing list if you'd like to get updates from them. MD Mentor has resources, but it also offers consultation services. So as with the insurance resources I mentioned earlier, we can't endorse any particular group, and we encourage you to work with your attorney to see if these or other resources might be appropriate for you. After your lawsuit is completely done, put it behind you. I found a really good quote here from there's a lady named Carla Malucci Ardito, and she says, learn how to exhale, and the inhale will take care of itself. I got to learn how to do that. But after you're done with everything, this should be purely an afterthought. If one of the expert witnesses in your case was an orthopedic surgeon and you think he or she gave inaccurate testimony, you have a resource with the Academy, the Professional Compliance Program. We have about 20 orthopedic surgeons that will review that testimony, and they'll come up with an evaluation in terms of whether or not it meets the standards that the Academy has set up, and there are 6 standards of professionalism that would apply. So I wanted to give you a little bit of background about the program. It started in 2004 at that 2004 annual meeting, and our members really wanted a way to address the issue of inappropriate or fraudulent expert witness testimony. So the Academy developed this whole program, a set of hearings that goes through a pretty lengthy process that could take up to a year. But at the end of it, as I said, 20 or more orthopedic surgeons have looked at it, and if they agree that there's a violation of our standards of professionalism, there's some compliance action that can be taken, and we'll talk about that in just a minute. Here are the 6 standards. Here are some information on the standards of professionalism. It is a mandatory standard of conduct for AAOS members. As I said, there are 6 of these standards. It's derived from our Code of Medical Ethics and Professionalism, and the fellowship has to vote on every new standard of professionalism or even to revise any of the existing standards. So let's figure out what they are. We have one on orthopedic expert opinion and testimony, and that's the one that gets the most activity. Providing musculoskeletal services to patients, professional relationships is another, research and academic responsibilities, orthopedic surgeon advertising, and then the 6th one is orthopedic surgeon industry relationships. I want to quickly walk you just a little bit through the grievance process. This is a way for one fellow or a member to file a grievance against another fellow or a member. It starts out with the Committee on Professionalism. Ironically, we call them the COP, which does an initial evaluation of each grievance. If they think there's something there, it starts out with a hearing. 8 or 9 members of the Academy that sit on this committee. Whatever their findings are, usually it goes to the next level, which is a Judiciary Committee hearing. And there are 6 orthopedic surgeons there. The Board of Directors makes the decision on any grievance that would impact membership. Important to note that AAOS doesn't take any patient complaints. This is purely just a peer-to-peer type of a program. Levels of sanction. Once the grievance reaches the board of directors, they've got a number of options available to them. They could take no action, finding that there's no violation of our standards. They could issue a a letter of concern, which is a private letter that goes only to the member whose behavior was cause for concern, but that behavior didn't reach an official violation of the standard. A reprimand is still a private matter, but the party filing the grievance gets to find out what the results of the evaluation were. From there, it gets a little more serious. As you can see, a censure is public. It goes to the opposing party. We publish it in the AAOS now, and we send copies of it to all of those medical and orthopedic related entities. Suspensions and expulsions do all of that, but in addition, they lose their academy membership for some defined period of time if they're expelled. And then expert witness cases must be reported to the National Practitioner Data Bank. The Department of Health and Human Services considers expert witness testimony to be to have an impact on patient care, so they require us to report those. Give you some grievance statistics here. In the almost 15 years in this program, we've had 224 grievances submitted. There have been 96 hearings of the COP, 42 hearings with the Judiciary Committee. It's resulted in 30 people being suspended. The board has actually expelled one person. That's obviously reserved for some pretty serious cases. And in this instance, I think it was we'll call him a serial offender of the standards. So let's talk about the Sports Medicine Licensure Clarity Act of 2018. This is considered a really big advocacy win, and it involved a lot of healthcare provider associations such as physical therapy, athletic trainers, sports medicine. They all work together to get this law passed. It preserves access of athletes and their teams to sports medicine professionals who provide high quality and continuous healthcare services. It protects those team doctors when they're traveling with their teams and allows them to, practice in those secondary states. A couple of reminders, while this act is a helpful protector for team physicians, there are a couple of restrictions. They can only treat teams for that event, but they can't treat any spectators. They can travel to the hospital with their athletes, but they can't treat at that away facility. They have to have, both the medical license and the privileging requirements for that state and that hospital. They can treat the athlete for a brief period after that event, and that could be as long as the next day while they're away in the secondary state. Finally, let's talk about some humanitarian missions and other types of international efforts to provide mission services. Please check in with your institution to see if there are specific trips that are endorsed or covered. Please go with a reputable group. Ask about their insurance coverage. Make sure they have any required licenses, and they can help you meet any licensing requirements that are imposed upon you. You want to check with the CDC. We all know where to find their website now, and get any appropriate vaccinations or medications based on the location. And be aware if there are any illness risks for that area, which there may not be a vaccination available. Check with your professional liability carrier and your life insurance carrier to see if any supplemental coverage is needed. And finally, let's make sure that all of your legal documents are in place in the event of an emergency, things like your wills and your powers of attorney. And you want to check with your attorney about all of that as well. So that's it for what I have, and I'm happy to take questions at the end, and we've got an option here to put questions in the chat box. Thank you.
All right, Melissa, thank you so much for that great and informative talk. I thought that was quite helpful. We'll move on to Dr. DeMaio's talk now.
So my task this evening is to talk about legal issues in your practice, and I really want to thank Dr. Murali Larson for arranging such a tremendous webinar, which will be on the website. Okay, so my topics today are going to be a little bit of background. I'm going to go over what I consider controllable factors and uncontrollable factors for this issue, common cases going to litigation, and some special situations regarding residents and trainees, and then a little bit about federal medicine. Let's talk a little bit about lawsuits. So medical malpractice dates to before Hippocrates, maybe even before attorneys. It takes a toll on you and your practice, and Dr. Murali Larson is going to talk about that, but it could actually take about 1 to 2 years. There are 3 types of medical malpractice, including product liability, liability of healthcare organizations, and then medical malpractice. So what are the elements of a claim in a lawsuit for medical malpractice? Well, the patient must be under your care at the time of the alleged injury, and you, must have did not meet a reasonable and expected standard of care under similar circumstances, and there has to be evidence to prove that something happened in a negative manner to the patient. So in reviewing for this talk, there's a lot of information out there. I mean, it's pretty massive, from attorneys, from doctors who are attorneys, from healthcare systems, et cetera. There's quite a lot out there. Not a lot of peer-reviewed studies, but a lot of information. And so I tried to group it in a manageable way that I would consider controllable versus non-controllable factors. So the controllable ones are for we individuals as surgeons, like how we present ourselves to the patient. I'll go over that a little bit. Explanations we give to the patient, and also our healthcare team at the pre-op point, post-op, what we do with complications, and then the all-important informed consent. We're going to talk a little bit about our role and how we control the quality of care and how we might minimize the chance of being sued. And then, of course, there's a ton of things that are totally out of our control. No one could have predicted how extensive this pandemic would be, even for the people who thought there was a pandemic coming up, just like we can't control who's going to come in on call and some other things that are out of our control. Surgeon attitude is something that we definitely can control. And this is where women physicians are thought to have a little bit of an advantage, because we tend to be more cooperative, we tend to be better listeners. I think it really comes down to simply do unto others what you would want done to yourself. And, you know, there's a whole interesting article about this called Love Thy Patient, trying to be understanding, caring, and to be a good listener. Try to establish lines of communication that are meaningful. You have to have confidentiality, and then what I call the 4 A's, not the 3 A's, but the 4 A's, that's me: availability, affability, be positive as best you can, I mean appropriately so. Have your ability, be at your top game, and then anticipate problems. I think that really helps a lot. There's another fascinating article about the concept determined by Pellegrino and Thomasma, which I had not heard about before, which is this virtuous orthopedist. Be good to the patients. Try to have time with the patients. And they had this way of evaluating 500 physicians. 103 were orthopedic surgeons, and people got much better scores, and patients respected them more and thought more highly of them when they spent 15 minutes or more at a follow-up appointment. And, you know, that's pretty hard to do in this day of RVU. Other attitudes about us as surgeons, this was really fascinating because it reminded me of my time on active duty when I took care of people in the flight arena, aviation. The FAA and the Canadian Air Traffic Administration developed this questionnaire in the evaluation of pilots that was supposed to predict, and does to some extent, when they're most likely to have behaviors that result in preventable accidents. And so, interestingly, they found that this constellation of a macho persona, being impulsive, being anti-authoritarian, that sort of, you know, defiance type of thing, and excessive self-confidence, not self-confidence that you need to be your best surgeon, because that really needs some confidence. Like, no one's going to do an operation if you're not confident that the risks outweigh the benefits. But this overly self-confidence, and they devised this hazardous attitude scale. And then they went to this variation group, which is a bunch of scientists, a bunch of professionals that are orthopedic surgeons and traumatologists that do a lot of orthopedics. And they found that of the survey responders, which was a high response rate, of which 92% were men, so we can't really say much about women here, 38% had at least one dangerous score, and that was macho and over self-confidence. So just having this leads to the conclusion, if they were pilots at least, that they would be at high risk for a preventable crash or bad outcome. So that's not good. We can be more aware of that and prevent that sort of attitude, because it's not helpful in surgery. Getting to explanations, you know, our patients sort of have interesting perceptions of us, like that little cartoon. You know, maybe that's what they're thinking of us. So we want to have good relationships. We want to be honest. We want to be fair about the consent. Obviously, this isn't a talk about shared decision-making and consent, but let's face it, it's not really shared, because we have far much information than our patients, way more, tons more. Even when I had my total hip, you know, my specialist, my surgeon, Dr. Ted Lambert, he had far more information about it than I did. So, you know, you have to keep that in mind. So be fair with the consent. You want to tell your patient and the family the finding at surgeries if anything happened that you weren't expecting. You got to be very clear about rehab and continuing care. And then if there are complications, that's the time that I learned from one of my mentors, Dr. Jean Galvin. That's the time when you need to spend more time with the patient and their family. You don't want to have any kind of perception that you're not involved, that you're not caring. And then, of course, there's the documentation that we hear about like ad nauseum, but you really got to document not only to the patient, the indications for surgery, that there's the best timing, the best optimization of surgery, the data that supports your decision-making and what you do, and the discussions you have with the patient. Other things about the controllable factors are quality of care, but this should have an asterisk on it. What do I mean by that? What I'm talking about is in surgery. In surgery, we have the scalpel. We have the retractors. So we are in charge at that moment of the quality of care, of our approach, how we do the procedure. And this study by Mattson was very disturbing in the sense that of the claims that were filed, 1/3 had to do with disabling injuries that included amputations, nerve and brain damage, permanent things, obviously. And it had to do with our technique. It had to do with our failure to protect structures. A smaller percent were how we manage complications. So you really got to be involved with that. And you can see in this graph, it's hard to read, I know, but the blue square is the outlier. And what is that? Failure to protect structures in the operating room when we are the surgeon. And then the second one was the complication, and then the other was a fracture management error, which we'll get to in a little bit, other kinds of things. But, you know, at that moment, we are the agents of the quality of care. The other thing about quality of care is when you have a major trauma, we could have done everything right. You know, we're not all traumatologists, but a lot of us are involved with trauma. And, you know, the patient is resuscitated, the patient lives, but that big trauma has a distracting pain. And so you've got to be very alert to compartment syndromes, especially when there's a change in sensorium or drugs on board of any kind. And also think about doing another secondary survey when the patient wakes up and after the big operation, because of the things that are missed, they're smaller things, but they can be very disabling to the patient, like a carpal fracture, or Lisfranc injury, major sprains, subluxations. They can't do rehab. So before you get them out of the bed, you know, consider doing that. The other things about the controllable factors that are minimizing lawsuits and also do come under somewhat of quality of care is risk management. But when you think about it, what that's about really is to be at the top of your game, to know everything that you possibly can about your cases, to stay on the cutting edge. and to optimize the medical management before elective cases. We can't really optimize management before trauma, but we can certainly optimize the kind of operations we're doing if we're staging things and what we're doing. And there's really only one article I found where there was this Dutch retrospective survey where they looked at how patients were managed, and they found that this one particular, for orthopedics, this is a surgical patient safety system at the time of surgery. Okay, so not just the training, not just the timeout, but other things in terms of managing the patient. They would have picked up 29% additional factors that might have presented 40. Now these were trauma patients, so 40% deaths and then 29% associated with permanent damage. So that might be something to think about with trauma to address some of what Dr. Mattson found. So how do we, again, have our best quality of care? How do we have control to minimize problems? And it's not just buffing the chart and practicing defensive medicine. It's basically in the little purple box. So they had a study where they looked at 290,000 claims for all kind of surgery and medicine, and they found that the #1 claims were on obstetrics and gynecology, then internal medicine, with orthopedics being #3. And then they had people that look at risk management for a living, including doctors, physicians who are also attorneys and attorneys. And this is not surprising. This is what, you know, we're trained to do, and very good doctors do intuitively. But there is good communication. They get consents. We stay up to date, follow up on tests and referrals. We really need to do that so that we're not missing things. And then, you know, we want to show compassion. The other controllable factors that we have, you know, are the ED. We're not in charge of who sends us referrals. And there was this one study from the Society of Orthopedic Military Surgeons that SOMOS, that 22% of consults to the orthopedist at the hospitals they surveyed were accurate. So that means most of them are inaccurate. And what were they? They were too general. They were incomplete. They had a grossly misdiagnosis, or the workup was incomplete. And of the workups that were incomplete, 70%, over 70% had poor imaging. So that's not so great, because you're making decisions and you're going down a path that could be awful based on incorrect information. So ask a lot of questions. Make sure if you decide not to go in, that you've got as much good information as you can, and you may want to write down a few things about the call. Other things are when you look at traumatic fractures and we're involved with, you know, whether as the traumatologist or the person on call, you know, essentially these are cases that have a lot of liability associated with them. Most of the time they ruled for the doctor over 60%. I'm sorry, but the awards were high at almost 4 million. And when they settled the award, it's tend to be less. And interestingly, when you looked at the fractures involved, it wasn't pelvis or femur, it was radius, then followed by the femur. So it was interesting there. So overall, what are some of the common malpractice cases? One is lack of care. So you want to make sure that you're always understanding the situation and delivering the best care you can. Problems about informed consent, where patients really didn't understand what was going to happen to them. Battery, which is basically those individuals that have unconsented touching, and we know a lot about them in the news. Luckily, there's only one orthopedist that I know of that's in jail for that. And then there's vicarious liability, which is essentially your office staff who is acting on your behalf and may not be doing it in the best interest of patients because we haven't been clear about our intent and have standard processes and procedures. And abandonment is that break in contract where we're not taking care of the patient anymore, where we didn't give the patient reasonable notice and we didn't arrange for additional follow-up or referral. So take a look at when you're seeing patients and when you're not, and make sure if they're not coming back that you try hard to get them back. Common malpractice cases are those that we can see intra-op and post-op. They happen with acute care, more common in trauma than elective cases. And you'll see here, this was another very interesting article from Dr. Suk, who is an attorney as well. And the top three are any kind of fracture, spine, and total joint arthroplasty. And so here we have it, fracture fixation. What were the problems? Management error. Failure to protect tissue, and then we had spine, then we had, again, failure to protect tissue, and then for knee arthroplasty, in the Matson article, it's implant malposition. So do what you have to do to make sure what we're putting in is the right size and in the right place. If we look at the surgery claims here, this first study is the largest one in adults. And again, it's fracture fixation problems followed by total joint arthroplasty and large mean awards. The people suing had the most success with fasciotomy and treatment for infection. And what was interesting was carpal tunnel was a third. The Gailey article is the largest number of claims I could find with pediatrics. And again, fracture number one, and then that was followed by missed DDH. These are two other studies basically going over the claims, and I just wanted to show you these mostly because in this first study, the surgeon won most of the time, but the mean awards are high. And the last study I brought up because it had estimates on the far right on the bottom of the cumulative risk. And this was for an Italian study where they looked at 635 claims for all Italian orthopods. So let's go briefly over a few special situations. Residents. In general, residents will be named in a lawsuit if they are involved with the staff who's named. Pretty much everyone gets named. And the trend, interestingly, is to assume that the resident is a bona fide licensed physician, maybe at a little less level than the attending staff, but often they are considered specialists. There are differences by state, but the big deal is that you, the attending, may and you should be ready to be held as accountable for lack of supervision. And the JAMA study found that the junior residents, 1 and 2, were, I think, I would have thought they were considered not vulnerable, but are most vulnerable. And I think it's because the people suing were going on the lack of supervision, which was cited in 55% of these cases. In pediatrics, again, fractions, whether you operate or not, are very high liability. And one of the interesting phrases I found, which is definitely true, there's no hypochondriacs in CAS. So please, if anyone's complaining of that, they're considered high risk, be on top of that, especially when the patients have impaired sensation, spasticity, or can't say they hurt. I'm just going to say for the federal medicine, you can be named in a lawsuit. You're not sued individually. They're suing Uncle Sam, but it is a tort process. It has its own special evaluation, and you can be named as an individual surgeon with your name being sent to the National Practitioner Database without a doubt. Last, I want to go over a few things about women. Women physicians are supposed to be and have been rated to be more patient-centered, more collaborative, and having more discussions. In a survey of 608 physicians of 2 large HMOs, far less women were sued. 26% women sued and 49% men. PhD research by Sarsons did find a factor that was fascinating. She was getting her economics PhD, and what she found was that there was an intraoperative patient death, that gender was the #1 factor associated with referral after the adverse event, the death. Women were judged more harshly than men. When they had a death, they experienced a 54% referral decrease, and there was a spillover effect to other women surgeons in the same area, not the same practice, the same regional area. The other interesting thing was if there was an event that happened before the surgery, or the patient was so ill that unexpected survival was discussed, meaning the patient had a high risk of death, the referring physicians were more likely to send their patients to men's surgeons rather than the women's surgeon who had similar patients. So if we look at the one retrospective study of post-op outcomes on looking specifically at women, and these were orthopods, women had a 30% less mortality, readmission rate, and complication. And then another retrospective study of just one company showed that there were more claims. They were other surgeons besides orthopods. There were definitely more claims for males but women's claim severity when they did have a claim was higher. So in summary, we, I think, know how to be very good doctors. We just have to document it in a way that shows that we're being careful and having the right indications. It's a sacred duty to serve patients, and I know all of you out there that are listening feel that way. And if you're your best surgeon, you're in a much better case of not being sued, but the risk of being sued remains very high. These are some references for further reading that are on the web page. When you get, you'll be able to see that. And we'll take questions in the chat box right now, and Dr. Murali Larson will address them at the end. Thank you very much.
Thank you, Marlene. That was great, Dr. Murali Larson. So yeah, I was inspired to organize these talks. It's not the sexiest topic, and it's somewhat anxiety producing in this high anxiety time where we're dealing with a pandemic, but I think it's a really important topic to address. I wanted everybody to, whether you've ever experienced having a claim filed or not at all, which is probably the case for many, particularly people in training or early in their careers, to be more prepared and more confident and able to handle this, because it's something that you really are going to have to deal with. Unfortunately, chances are you will get sued. So almost 100% of orthopedic surgeons by the time they retire will have been sued, 91%. So you know, coming out of training, it's not necessarily something that's immediately on your mind, but it's something you really have to be prepared to be able to deal with. So we talked about the most common reasons that were cited in Melissa's talk and Dr. DeMaio's talk. We are pretty comparable to OBGYN and general surgery. So physicians who perform procedures and surgery, of course, are going to be a little bit at higher risk. And I can say that, you know, when you are hit with a lawsuit or a claim, it really feels like you have a target, and it can feel like you're completely blindsided and not prepared, and you can feel like you really have that target on your back, and you want to, you know, be prepared, go in whether you've had a claim filed or not. You can take all the appropriate precautions, you can be the best doctor and best surgeon you can be, but realistically you are going to have a lawsuit filed against you, so you want to go in and be prepared. And even though you may feel like you're a target, you want to, like Melissa said, take a deep breath, you know, deal with those feelings and address everything appropriately and in the best way possible. So I know for myself, during my residency, I remember vaguely having a couple cases that were mentioned among the attendings and residents where there was actually wrong site surgery. And, you know, I wasn't personally involved, but I remember those cases not really being discussed all that much, and malpractice not really being discussed. I think the mentality during orthopedic training was just, you know, just be better, get better, don't make mistakes. And it wasn't something that was really discussed much. And so I came out of training not really being prepared to deal with malpractice or really thinking much about it. And I want to point out this, there's a resource available right on the AAOS website that I think is good reading for everybody. So it's a pretty quick read, essential legal knowledge for orthopedic surgeon. I think it's a really good practical guide for all of us. So I think that's something that everybody should take a look at. So in terms of, you know, myself as a physician and a surgeon, I thought everything that we had learned, that ways you can protect yourself or minimize your risk, is really taking the time to explain everything to your patients, particularly pre-surgical or post-op patients, talking to them about every possible risk, what they can expect, giving them time to ask all of their questions, following up with them. You know, I talk to my patients before surgery, I call everybody the day after surgery, see if they have any questions. So I really feel like I take a lot of time to connect with all of them. I sit, I look them in the eye, I really care about them as people and about their lives and their goals, and how I can help them best optimize all of that, and, you know, heal them. And additionally, like Dr. DeMaio pointed out, you know, recognizing treating adverse outcomes, following up on studies, following up on referrals. I can say personally, I've had cases that I thought potentially were not the best outcome. For instance, I had an AC joint reconstruction that loosened up in the months following surgery. And I, of course, explained that to the patient, talked about the options. And I recall this particular patient, he and his wife were pretty upset. And that was one case where I thought, potentially could lead to some kind of litigation. But I think because it was something I had really explained to them, something I talked to them about, and really guided them through it, I think we all have cases like that not every outcome is perfect. It really can't be as excellent of a surgeon as you are, as much as you prepare, as good as your training is. You can't have perfect outcomes even, and you have to acknowledge that and deal with it. And I think that's something that we all know, and we just have to continue to practice. So in terms of protecting yourself, you definitely can minimize your risk by, being a good doctor and being a good surgeon. So developing a relationship, communicating, choosing your patients. So with elective surgery, there's a limit to the patient's understanding. I think you can explain everything you can. You can explain in terms that you think your patient can understand. But there's always going to be, a certain limit. So you definitely want to take the time to explain everything. But, there's going to be a certain, sometimes a certain barrier there. And then you also want to think about, choosing your patients in terms of if you have the appropriate training and skills to address the injury they have. So I think that's definitely a balance. I know personally I want to take on some challenges because I feel as though I have the appropriate skill set and the appropriate training, and I want to do interesting cases that may be challenging. At the same time, I don't want to take on certain complex revision cases or cases that I think are not appropriate for my skill set. But I think that can be plus minus. I think there's some surgeons who avoid taking on complex cases, but there's some of us that want to take some of those on. And of course, that's going to potentially open you up to, potential complications. So I think regularly evaluating the kinds of cases you want, what your appropriate skill level is. Once you've been out in practice, if there's certain kinds of cases you haven't done in a long time, choosing maybe not to do those, or deciding that you do want to take on certain cases and building your practice accordingly, doing training courses, talking to other surgeons that you trained with, etc. So when a claim actually is filed against you, so I had my first claim filed and I really didn't know how to handle it. I got served a letter, so you get served an official letter, and it could be, I was in the middle of clinic and I got this very official looking letter that said that I had been served, and I didn't really know what that meant. And I basically just freaked out and was, distracted in the middle of my clinic day, and I couldn't really think about anything else. And, I didn't really know how to go about it. So, I didn't even think, how do I deal with this? I just kind of freaked out. And, basically just the actual, brass tacks of it, just practically, is you have malpractice for a reason. For me, I thought, I pay my malpractice every year. It's just a certificate I showed all the hospitals where I'm credentialed and surgery centers, and I pay it and I don't really think about it much. But of course, you have it for a very, very specific and important reason. So your first step before you really do anything else is just to go on your practice carrier's website, click report a claim, and just enter the information about the case. And the next step that happens is they have an agent assigned to you, and that agent will talk to you briefly about the details of the case, and then they'll assign you counsel. And then, of course, you'll be discussing everything with your counsel. So, for instance, my case, it's a case that's now closed, so I'm able to talk about it a bit without disclosing any details. But I was actually the assistant surgeon on a case. It was a patient who had a rotator cuff repair with a biceps tenodesis, and I was helping one of my senior partners with the case. So it wasn't a patient that I had specifically chosen to take to surgery, but I was the assistant surgeon. And the patient, in follow-up, my senior partner was only going to one of the two offices of the practice, which was a bit far away in a different city. And so as a favor to the patient, I followed the patient post-operatively. And essentially, the patient's biceps tenodesis looked like it was a tenotomy. So it looked like the anchor in the bicipital groove had essentially failed. And so the patient had deformity. It functioned as a biceps tenotomy. So realistically, the patient had almost full strength. It was a workers' compensation case, and the patient had trouble, he said, going back to work. And so I continually requested authorizations for more physical therapy. I gave him appropriate restrictions at work, and he just didn't really seem to improve. Of course, I explained to him his options about revising this, but also discussed that biceps tenotomy is a perfectly accepted treatment for biceps synovitis. And I followed the patient for several months. He didn't really follow through on a lot of his physical therapy. He didn't really seem motivated to get back to work, but I kind of, held his hand through all of it, and really just tried to help him through all of it. And I got served a letter that he had initiated a lawsuit against the primary surgeon as well as myself several months later. It turned out this particular patient had about 50 open lawsuits in the county, just various lawsuits. But anyway, I was named and I was served, and I was named in this lawsuit. So sort of trying to get over some of that shock and feeling a bit almost betrayed by a patient that I had really tried to help, and that I hadn't really thought that I had caused any harm to, with somebody who I had really just purely tried to help. So it's something that is very stressful, and can distract you and take you away from other things. But you kind of have to know that it does take months to years when you do get a claim, which becomes a lawsuit. My particular case, the patient ended up dismissing it, but it did take about 8 months for the process, and several meetings with a lawyer and lots of discussions, and really a lot of stress and anxiety on my part, just to know that when you get served or you get a lawsuit filed, preparing for the case can take quite a bit of time, and that's something that I think can create a lot of resentment on the part of the surgeon. Is it's time that's not compensated, and it's time that's stressful. It takes you away from your practice, for your family, from other things you want to do. I thought the way that Melissa Young framed it, that think of it as an essential part of your career and think of it like boards preparation, I think is actually really helpful. So when a claim is filed against you, we talked about the logistics and the practical steps to take. Emotionally, it takes a really big toll, and we touched briefly on this. I thought those resources that Melissa pointed out were great. The resources I actually didn't even know about until discussing this with her. So definitely, your partner is going to be, or your friends are going to be a huge source of support. They can't obviously know all the details. They can't really, know what it's like to be a surgeon unless they are, and you can't discuss, all the details of the case. But I think just being supportive and talking about how you feel about it, that you're disappointed, that you're stressed out, that you feel betrayed. I think all of those are great things to express and to have your partner support you. I personally found it really helpful to reach out to a trusted colleague, and I would say meet in person. So I had reached out to a few different colleagues, and I had talked about things over the phone with a couple of them, and I found one that is a trusted colleague of mine in the same community. He's about 15 years ahead of me in practice, and we just, instead of talking about it over the phone, we met in person, maybe for 15 minutes, but I found it really helpful. He gave me great advice. He had, shared experience. And one piece of advice he gave me was to compartmentalize. So think of, there's process with these claims or lawsuits that there's sort of different stress spikes, because you get served the letter, and then you need to figure out your first steps, and you get matched up with a lawyer, and then there'll be some time where the lawyer does some work and then reaches back out to you, and then you meet, and there's different notices that come through. So there's kind of these different spikes when you get these notices or sort of have to deal with it or have these meetings. And his advice, and I think was very sound, was to deal with it when you have to deal with it when you're in the moment, and then put it aside and go back to your practice, go back to your family. Don't bring it into the different facets of your life, because again, these processes can take several months to years, and if you let it drag you down or bring it into these different parts, it can really stress you out and create a lot more stress and anxiety than it needs to, because it is something that you do just have to deal with. Some somewhat good news. So my particular case didn't go to trial, it got dismissed, so that falls in the 25%. About 25% will go to trial, and about 37% end in settlement. So the settlement is the highest percentage. Often surgeons, from what I read, they will actually go to settlement, because sometimes going to trial and seeing the lawsuit through takes a lot of time and effort, and that takes time away from your practice. And so settling can sometimes be the easier route. And that's just, what I read. But the odds are definitely in your favor. So the jury finds in favor of the surgeon in the majority of cases. So that is some good news, I think, to give us some support. For the plaintiff, if there is a payout, the payout's typically over $3 million. So if you've seen your malpractice contracts, that those numbers probably look familiar. Usually it's 1 million, 3 million. So that's where that 3 million number comes from in terms of a payout. And if it is settled, the average is about 1.5 million. So going forward, I can say personally, having had a lawsuit filed against me, it definitely does affect me. I think there's some things that can be potentially good about that, meaning being very careful about documentation, reiterating that it's important to make sure the patient's well informed. So in the research I did, seeing that majority of orthopedists say that the threat of another affects them, I would think it would be 100%, but apparently but it's definitely the majority. And a lot of people will say it's with every patient and almost all of the time. So it's something that will affect you going forward. And in the survey that I read, what would these surgeons do differently? Most say that their treatment met the standard of care. And I think, I would say for myself, that rang true for me. Never taking a patient on, so that addresses the patients that are more complex. Of course, as we discussed, when you're taking call, pretty much you're dealing with what you're dealing with on call. Potentially there's certain complex cases you could transfer, you could defer to one of your colleagues, but for the most part, when you're on call, you're going to be managing those patients. So that's not always really your choice. Better chart documentation. Of course, you always want to be detailed in your documentation. Document well that you talked about the specific risks of the specific surgery you're doing, and also afterwards, detailed exams. And then a small percentage said they would get a second opinion from a colleague. So that's always an option as well. So I know for me personally, I thought, going forward, it's nice when you're filling out all your forms for credentialing and privileges, and they have those 14 questions that you have to attest to. And it's really nice to just check no, 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 and have a clean record. And I really, hate having to fill out that I've had a claim filed, or, and have to answer that question. One, taking the time, and two, just feeling as though there's some kind of mark on my record, or, this is something that it's almost, I feel ashamed of. But I think it's not something that we really should worry about. But, it's sort of a source of pride to have this clean record, and now, having something I have to check yes and explain, it's not something I wanted to do, but that's just is what it is. And I was also worried about whether my malpractice rates would go up. So it seems like they go up every year, which they do. I discussed this with the lawyer who would assist me with that case, and he said that really one claim, it's not going to make your rates go up. Potentially, if you have multiple claims, it could. And of course, malpractice rates are set because these legal fees are so high. For instance, in this case that I thought was pretty frivolous and got dismissed, still the legal fees were several $1,000s. So that's contributing to the overall cost of malpractice, of course. So orthopedists experience of being sued. So the depression, anxiety, and stress are definitely not to be overlooked, and we discussed some of the resources for that. It should be acknowledged, and I think it's not. I had organized this topic because I felt like it was something that I really hadn't seen covered and didn't feel prepared for. And I think acknowledging that there is a lot of these feelings that go along with being sued. Feeling disillusioned and betrayed by patients in the system, I think that's very common and certainly something I experienced. I think when you feel as though you've trained really hard, you studied really hard, you prepare for all your cases, you take the time to explain things to your patients, you go above and beyond, you do things that are not compensated but are helping you, treat the patient in the best way, and then your patient sues you. I certainly felt very betrayed, and I think that's very common to feel that way when you've really, the patient-doctor relationship is two-way, and you're quite invested in your patients. And then when you feel as though you've done everything you could and really tried to help your patient, you can definitely feel very betrayed when you get sued. And then the system in general. Worrying about professional reputation. So certainly that's a worry. Just, maybe personally feeling a little bit, worrying about a skill set or ability as a surgeon or even just reputation. Definitely, I think being sued can interfere with all of that. And I think there's definite interference with family work, personal time. There's a lot of time invested in preparing for litigation or reviewing the case, and it feels very frustrating to feel like it's time that shouldn't be spent doing that. But unfortunately, it is something that needs to be done. So the long-term effects of being sued, there's definitely decreased trust, I think, overall in the system. Treating patients a little bit differently. So I think, I've always felt is that I've had really good connections and relationships with my patients, but I think sometimes you think you do, and if you've been sued, you feel like, well, you can't always assume that because it's not always a two-way street. You may feel as though you're invested and you really care a lot about your patient and you're doing everything with an appropriate skill set and really taking care of the patient, but they may have a completely different perception. You can definitely second guess your capabilities if you've had a complication, and definitely if you've been sued. You can definitely get disillusioned overall with medicine and surgery. So the advice for other orthopedists in the survey that I read is document everything, of course, in a very detailed manner. Be thoroughly prepared for your cases, of course, but specifically in this instance for the lawsuit. So get good legal advice early. Listen to your lawyer. Be patient. Be likable. And this is stressful, but it's not going to end your career. You're not going to lose your license. It's just you have to go through a stressful experience, but overall, it's not going to deter you. And these are all the references. I would particularly point out the essential legal knowledge one that I discussed that's on the AAOS website. And thank you, everybody, for your attention. Any questions, type them in the chat box. We'll get to them at the end. We'll get going with Anne's. I know we're running a little bit low on time here, so we'll get going with Anne's speech.
Great. Thank you, Dr. Murali, Larson, and I'll just wait for controls to be handed over to me. I'm going to spend the last 15 minutes or maybe 14, so we have some time for questions at the end, talking about how to mitigate risk in orthopedics. And just as we get our controls set up, I'll let you know what I'm going to cover in our time together. And I want to talk briefly about high-risk cases, and we've had such a great overview of some of the things that you all are seeing in the orthopedic world. Informed consent, which you've heard quite a bit about already, but being a risk management professional, I feel it's important to bring that home. We'll talk about unexpected outcomes, adverse events, and how you can engage risk management in your practice. So here we go, perfect. So we just covered that. So what I'd like to do is start with just talking about some potential scenarios that I'm sure will be familiar to you all that could lead to a case being high risk. And as I go through my next few slides, I'm not going to talk to every single point because I want to put in front of you something to think about as you're addressing your high-risk cases, and that's really just the basic principles of risk management. And I think this is a great way to approach some of your work. So there are 5 basic principles. You've heard a lot about 2 of them already today. And the first one is really risk identification. And when you come into a scenario, you in your head start thinking about what about this presentation scenario, patient procedure, the systems in place might bring risk to me or my patient. The second part is risk analysis, and that's when you're really trying to decide how bad could it be? What could be the worst outcome that could happen here, or how often could this outcome happen? The third is really risk control. What am I going to do to try and decrease the risk in this particular situation? And then the last two are risk financing and claims management. And you've heard quite some good information about not only malpractice coverage, but the claims management process with our two previous speakers. So if I were to talk about this first scenario, that's where a patient presents with a complicated injury in the emergency department when you're on call. And we've heard that can bring stress to you all. It's often an uncontrollable situation. But if you think about the risk identification piece of this, think about what's in front of you. So if that patient who presents is an elderly patient, you can already start thinking about what is that patient bringing to the scenario to begin with that is going to impact your decision-making with how you treat this injury. If they have physical capacity that is diminished and you're thinking about a surgery, are you really going to increase their functional capacity by doing that? And what specific risks might they bring from a medical or surgical history that would change the way you think about it? Other things, too, that are equally important is, does this person even have capacity for medical decision-making? Are they considered to be legally competent? And is there someone there who can help with the decision-making for what you're going to do? And do you have an adequate history and physical to really make a decision about them? Pediatric patients, you saw some of the claims data on that. You're going to also be thinking about, from a minor perspective, what if this person shows up in an ambulance, is a minor, and you don't have a parent or a legal guardian to talk through these, through the scenario with you, and perhaps it's a trauma and you need to make a decision from an emergency perspective. So is the facility where you're practicing set up to manage pediatric patients well? Or is this a scenario where you might want to transfer to a pediatric-specific hospital? If your OR staff and anesthesia staff aren't used to managing pediatric patients, or if you don't have the appropriate post-operative facilities to manage them, that might be a consideration for you. And again, the consent issue is important as well. You also will be thinking about the resources that are available to you to support your diagnosis. Smaller hospitals may not have the appropriate radiology resources for you to get to the best clinical decision-making for what you think, what you're thinking about doing from a treatment perspective. If you don't have radiology in-house, you can't do CAT scans, MRIs, does that change your mind about how you might manage this particular patient? Who's going to be reading those films for you? And then as you think about these patients presented to you and you're trying to decide, is this going to be somebody that needs surgery? Is this going to be a problem that we can manage in the short term and send them home with some specific instructions? Really think about what your differential diagnoses are in this situation. Document them, of course, explain them to the patient or the patient's family member, and then make sure that your discharge instructions are really addressing what might require an urgent reevaluation. If you've casted somebody, obviously you're going to be giving good instructions around numbness and tingling and when they might need to come back and be seen sooner rather than later. Compartment syndrome could be an issue. And we also heard from the claims perspective, and I see this consistently. I've been in the malpractice and risk management field for about 30 years. I've handled malpractice claims myself, and I do a lot of work with the Coalition to Improve Diagnosis. And the failure to follow up on tests and referrals and lab results and radiology results really is contributing to what is probably the number one reason now in the field for physicians to be sued. So if you've got somebody that you are deciding to go ahead and discharge from the emergency department, ensure that you have a process in place to follow up on test results and referrals that might have been made under your direction. The second scenario that I want to talk about is if you are either performing a new procedure for the facility, maybe it's not a new procedure to you, or if you are performing a new procedure yourself as a surgeon, and it will be new for your facility as well. So Dr. Murali Larson talked about, the desire to do more complicated things, and of course, we want physicians and surgeons to be taking on more complicated things, so we have those opportunities for better treatment in the future. As you're thinking about that, some risks to identify and some risk control measures that you can put in place to really optimize the management is one, think about the training that either the person you're going to be scrubbing with as an assist or you yourself have gone through to perform this procedure. If it's just something that's a little more complex for an existing procedure, that's one thing. But if it's more like bringing on a Da Vinci for orthopedics, that's different. So you really want to be thinking from a medical staff perspective, from a medical staff credentialing perspective, does there need to be a specific delineation of privileges to perform this case? And do you need to have proctoring in place as well? Because what you don't want to have when you're bringing in a new procedure is a negligent credentialing claim that comes from that. And you also want to consider the experience or the training that your surgical team has received to assist you with this new procedure. So think about your training and what proctoring might be necessary. If you are the first surgeon to do this, you are going to be required probably to have a proctor. And who could that person be to support you to bring this to your organization? And then how are you going to monitor the quality outcomes? And this could involve a focused practice, professional practice evaluation for proctoring, especially for Joint Commission accredited organizations. Think too about new procedures. If you are bringing in a vendor or a device or implant representative into the operating room, what will you do if you need a different size of an implant or device that you are using for the first time? Is your representative prepared with more than one size, for example? And if that implant or device fails or there's some sort of damage to it or to the patient during your procedure, do you have a process to ensure that you have access to that device or implant? And what is the hospital's policy as far as keeping it versus turning it over to a vendor? We heard earlier about product liability. And if a patient is harmed by a device or an instrument, there's a potential for a product liability claim to be brought on. So you just want to have an understanding of what are the requirements around bringing vendors in the operating room. They're going to be identified as being present in the room if there's a lawsuit that happens. It's also important to ensure that they aren't participating in the case in any meaningful way. Your hospitals always have policies around that, and that they are appropriately credentialed to be there, depending on what your hospital requires, as well as their vendors. Other things to consider, we heard briefly about universal protocol, checklist, brief, and debrief. I really want to reinforce the use of briefs and debriefs, particularly for a new procedure. I'm actually an operating room nurse by background, haven't done it for a while, but I think the importance about briefs, and I'm also a team steps instructor, is this is your opportunity to really bring your surgical team together, create some situational awareness in the operating room. And it might sound something like, and I'll just use Dr. DeMaio. I'm Dr. DeMaio. I plan on doing this procedure today. I've got so-and-so here from the company with me. I anticipate this procedure will take me about 2 hours, and I'm expecting 250 cc's of blood loss or less. I would like you as a team to keep me informed if I start to exceed my operating time. I'd like anesthesia and the circulating nurse to keep me informed if my blood loss seems to be greater than that, because what you're doing is you're bringing your team on board to help you ensure that you're staying on track, and that you, if things seem to be going on longer, or you're, having a complicated case, that someone is helping you maintain situational awareness. And then, of course, debriefs are always important, particularly when things go well also. So what went well, what could we have done differently, and what do we want to do next time? And then just making sure that if you are doing a new procedure, that you have validated the competence of your surgical team if this is a significant change in what they might do, and that they've been trained to do this as well. That would be your circulators and your scrubs. And also, one critical thing that I don't think people think about often is the ability of your central sterile processing department in wherever you're operating to appropriately clean the equipment that you're going to be using, particularly if it's something that might be unique, such as what we've seen with endoscopes. We've heard about all the infection control issues with that. The third scenario is, let me just advance this here, just that the scenarios where the practice setting may not be appropriate for the complexity of either the patient or the procedure. I won't spend too much time on this, but I think it's important to give consideration to where is going to be the best place for what you want to do. And that a lot will go to bullet number 2 here, my contributing factor of patient comorbidities. So while you might ordinarily do a certain procedure in a freestanding ambulatory surgery center, the patient might be bringing different risks to that scenario that would lead you to have your procedure done in the hospital operating room versus the freestanding facility. That might be, for example, BMI limitations. So the equipment in the freestanding ambulatory surgery center may not be able to hold a certain weight, greater than a certain weight for your patients, and anesthesia might actually have limits as to the BMI that they would manage in a freestanding facility, whether that's from an intubation perspective or to be able to manage a post-op airway, comorbidities with cardiac disease, ASA classifications 3s and 4s. So you really just want to ensure that just because the procedure might be one that you would consider doing in an outpatient facility, the patient might change your mind about that. And then, of course, what equipment and supplies are available in each of those settings if there is a complication. You aren't going to be doing something in a freestanding facility where there's the potential for greater blood loss because you may not have the blood supply that you need, and how the staff in that facility are able to respond to emergencies should they occur with you. The 4th scenario really speaks to the patient's medical history and their ability to understand and comply with treatment and post-op care instructions. Those who have spoken before me this evening have really done a nice job about talking about this. We know that a patient's ability to understand and comply with our instructions can make a big difference as to the success or failure of their surgery, particularly when you've got some complex orthopedic procedures that may require long-term rehab or post-op care that's consistent. Again, we might have a patient that's not a good candidate. They might think that they can hike 20 miles after they have their hip replaced, but if they're 50 pounds overweight, that might be an unrealistic expectation for them. It may not be an appropriate surgical procedure for that patient because they're not the right candidate specifically for there. Other things that could bring risk to this scenario are a failure to order medications or ordering medications that are inappropriate for their condition, really based on their medical history. One of the things I know you all are certainly familiar with is the risk of a post-op DVT or PE. Is the medication regimen appropriate to manage that? Alternatively, has there been a failure to hold a medication preoperatively that might lead to complications for you during the surgery itself? So those are some risk mitigation activities to really ensure that you really understand the patient's medical history, you have the appropriate post-op or pre-op clearances, and that you have an understanding of what their medication needs are going to be both preoperatively, intraoperatively, possibly, and postoperatively. And then really getting a good sense as to their understanding of what post-op care instructions are, but also if they are in a situation where they may not have the resources to be able to carry out the post-op instructions that you feel are going to be necessary for a complete and thorough recovery. That's important to consider when you're thinking about what procedure is going to be done. If it's somebody who's going to need to get to physical therapy routinely and they live alone and they don't have resources, family resources or someone else to get them there, their compliance is going to be difficult. Same with, some of their personal habits perhaps might make a difference as well. Let me just move quickly to informed consent. You've heard that quite a bit. As a risk management person, it's one of my favorite topics, and I will just say I can't reiterate it enough. I think what's really key here is having a patient-centered dialogue. We know that shared decision-making is important, but I think being patient-centered and open to what they have to say is kind of key here. Obviously, talking about the risks, benefits, and alternatives to the procedure, I think everyone has heard those words over and over. It is important to be documented. What's also really critical, I believe, is explaining the realities of the care and knowing what the expected outcome could be and what the expectations for recovery are. When I think about, and then the complications that a reasonable person should know, I think being patient-centered, one scenario that I like to consider is a carpal tunnel release. If you were to do a carpal tunnel release on me on my left hand, I'm not going to be too concerned about some of the potential complications. I don't do much with my left hand. Sure, do I want it to function well? Yes. But if I was a classic pianist and that's what I did for a living, while it's a minor surgery, if you were to tell me that there was a risk of me losing function of my hand, I might think differently about having that surgery, and I might just decide to live with the pain. So that patient-centered conversation can be very important when you're talking about those risk, benefits, and alternatives. Validating the patient understanding, I think this has come out quite a bit in the conversation this evening, to making sure the patient understands what's being said. We really need to make sure that we're considering just reading level when we're giving out materials and when we're having that conversation. We always know we need to consider language barriers, and make sure that we're giving information to our patients and their family members in a manner that they can understand. So if we have to worry about a 4th or 5th grade reading level for what they're giving to them, then you should make sure that you have those resources available to you. And certainly, whatever written information you have, ensure that you have clearly documented what's been given to them. I know you probably do a lot of preoperative classes for some of your major joints, making sure that their attendance is there. And if you're requiring them to attend those classes before surgery and they haven't attended them, then you have to make your decision as to whether or not you're going to go forward with the surgery or not, if you consider that to be an important part of success for the outcome of your procedures. I'll just go briefly through disclosure of unexpected outcomes and adverse events. This really goes back to your informed consent, because that discussion is going to be the basis for any discussion you have when you're talking about unexpected outcomes and adverse events. I've seen some exceptional notes from orthopedic surgeons prior to procedures. To one the other day that literally talked about the 2 stages that they would do depending on what was found on the first stage. He addressed this person's age, their success for a revision. I can share the example with our information that we provide on the website afterwards. But just know that that's what's really going to be the start of your discussion. I think what people fail to understand sometimes is that you don't necessarily have to have the full set of facts of an event. If something is a little unclear as to what happened, perhaps in the operating room, but you feel that you need to have a conversation sooner rather than later with the patient and or family, just know that it's okay to go and acknowledge to them that, I understand that we had an outcome that we didn't expect. I don't have all the information right now as to what happened, but I am committed to getting that information, and I just want you to know that we will be having a discussion again soon. I can tell you what I don't know, but I don't know everything now. And so you don't ever want to put yourself in a position where you're speculating as to what happened. Just know that this disclosure around unexpected outcomes is not normally and should not be a one and done. You should expect to have multiple conversations around this. You also need to understand you'll have to give additional time and attention and information. There's going to be questions and concerns if it was a significant event. My experience has been that family members or patients will come back and back and back, and you just need to be patient and get the information, give them the information you have at that time, but don't make promises for changes that may or may not happen. Apology, I want to speak to briefly. There are, what you need to be aware of here is that there are state-specific laws around apologies. Right now, there are 39 states, and then the District of Columbia and Guam all have provisions around medical professionals making apologies or sympathetic gestures, but it does vary by state as to how those statements can be used in malpractice cases. So you definitely want to be aware of what that is in your particular case or your state. And then, of course, document any disclosure conversations, who participated and what was said. And that really leads me to how you can, when you can engage risk management. And it's a perfect time to work with your risk management colleagues if you do have a disclosure that you'd like to make and discuss an adverse outcome with the patient and family. I've kind of listed some of the typical ones we get involved in right above here on this, the first bullet point. But in our profession, we're really used to having these conversations and working with our clinical colleagues to help frame a conversation, to help gather facts, to help understand what happened, And we do a lot of coaching, quite frankly, and do some mock conversations if it's going to be a really difficult conversation. Another example of when to engage risk management, we have a lot of conversations typically around informed consent, around capacity, sometimes around competence. Those are two different things. But also when you have a patient that continues to be non-compliant, we heard that mentioned earlier this evening as well, or they're not adhering to a treatment plan, how can you manage that patient? When might it be appropriate to dismiss that patient from your practice? If that's something that you're thinking of doing, there are multiple steps to be taken to do that. So it's another good place to engage risk management there. I'm going to wrap it up because I know we're over time. So sorry for rushing through, but I want to give a couple of minutes for questions from the group.
Well, if anybody has questions, I don't believe there's a way that you can voice in, but if people want to type in anything now in their chat boxes, we can keep this open for a few minutes for questions.
And this is Marlene. When you were talking about the state-specific rules for the apology, is the most important factor that if you give an apology, it's implying like maybe negligence or a problem with the surgeon or something preventable? Is that why there may be rules that say don't apologize?
Sure. So really, that's a great question. And I think it goes to how you actually say what you want to say. So in my experience, it's generally appropriate anywhere to say, I'm sorry that you experienced this outcome. Because when you use those words, you're not saying, I'm sorry I did this to you. You're acknowledging that something happened to that patient that wasn't expected. And so you're apologizing that they're experienced the outcome. In some states, an apology is admissible, as possible evidence in wrongdoing or guilt. So I think it's a matter of coming up with that right statement like I used to express you feel badly about it, right? And so you want to acknowledge that you feel badly that they experienced something that wasn't expected, but you're not coming out and saying, I'm sorry that I did the wrong thing to you, because depending on where you are, that could be used against you, unfortunately. So I just as a resource for folks to know about where you can check it out, the National Conference of State Legislatures, which is ncsl.org, does list the medical professional apology statutes by state. So if somebody wants to know specifically if their state has a statute and what you're allowed, what the statute kind of gives direction to as to what you can state, that would be a website that's a really good resource for everybody to go to and look. Because like I said, not all states have one.
Thank you.
Okay, well, I want to thank all of our speakers. I thought that was quite comprehensive and very helpful. And I hope this is a great resource for people. If they weren't able to attend tonight, we'll have it on the website. And I think, we can create resources on our website for people kind of know where to go. This is definitely important information for all of us as practicing surgeons. So I think if there's no questions, we'll wrap it up. And people, of course, can submit questions afterwards. We can have an email way to do that and keep the conversation going. Yeah, well, thank you everybody for attending and have an amazing evening.
Thank you.
All right.
Thank you.
Bye everybody. Good night.